right, and as I mentioned, we're going to skip over to Representative Campos. Chair lays out House Bill 4905 and recognizes Representative Campos to explain her bill. And we do, Chair offers a committee substitute for House Bill 4905.
Thank you, Chairman Frank and Vice Chair.
I think if you make sure your microphone's on, or you can scoot up.
There you go.
Try that again.
Yes. Thank you, Chairman Frank and Vice Chair Rose and fellow members. Thank you for the opportunity to lay out House Bill 4905 relating to the definition of a neglect of a child and suit affecting the parent-child relationship, which DFPS is appointed joint managing conservator with the parent. Texas parents can voluntarily terminate their rights, called refusal to assume parental responsibility, or RAPR. Many children with trauma act out, skip school, and use illegal substance to test boundaries or numb their pain. Mental health issues are also involved, either with the children or their parents, and comes to a head with a child enters a mental hospital or the juvenile system, and the parents refuse to pick them up. RAPRs put the court and DFPS in a very difficult position, as no statute-defined abuse has occurred. But currently, the judge cannot order a parent to take care of a child they don't want. The state is appointed as Joint Managing Conservator, or JMC, but many families, even after receiving support services, will continue to refuse the responsibility. For those children whose parents refuse services or who fail to unify after services have been attempted, finding a new adoptive family is difficult, and the state is left to prepare for them for adult living. Many of these kids end up being children without placement. HB 4905 seeks to define RAPR cases with parents continue to refuse their child, and DFPS is JMC to be defined as neglect in Section 261.001 of the Family Code. Before appointing DFPS as JMC, the court must find significant evidence that the parent exhausted all reasonable means available to them for mental health services for the child. DFPS is able to provide these necessary services and has identified a licensed placement or kinship to meet the child's needs, which cannot be CWAP, like motels. If these and other conditions cannot be met, the court shall order the child be placed with parents until a licensed setting is available, or discharge DFPS as the child's JMC and dismiss the suit. The legislator must emphasize parental responsibility and ensure that if parents decide to refuse the responsibility, the state must have the means to do so. These means are not just financial or services, but also a safe place. I am open for questions, and I respectfully reserve the right to close.
Well, thank you, members. Any questions of Representative Campos? I want to tell you, I appreciate you. You know, this has to do with the CWAP issue and trying to come up with some possible solutions. And I can tell you, there are no easy answers, and there are no non-controversial answers when you're trying to address this type of issue. And I appreciate you working with people on it. I hope we can get somewhere that will, make things better, but obviously not just the CWAP issue, because that's not the only issue out there. That's the issue from our perspective, but we've got issue of parents handing over kids. How much should you push them when they do that? So I think there should be, we don't have a ton of testimony, but I think it should be good testimony, and we're also going to call up the commissioner at the end to address it. And but I really would ask every member to, I know we've got some people laying out bills and that kind of stuff, but I know most of the issues we deal with here are tough. To me, this is maybe one of the hardest. So appreciate you jumping in. This is kind of the issue we talked about, I think, on the maybe first or second week, and this is one of the responses to it. So any other questions? That was no question, but any other questions for Representative Campos?
Thank you, Chairman, for that. And again, this stems from the work that I did this interim, working with families, and just, it's a tough issue for all of us, and I know that we're all doing the best that we can for the betterment of our children, so thank you for that.
Okay, thank you very much. Chair, we're going to hear from a couple witnesses. Chair calls Christina Perrone. I get that right? Perrone, okay, I'm sorry. I've got you as Christina Perrone, testifying on behalf of yourself and the Texas Association of Family Defense Attorneys against the bill. Is that correct?
That's correct.
Okay, thank you very much.
Thank you again, Christina Perrone, and I am an attorney. I work in Northeast Texas, rural counties up in Northeast Texas, and I am intimately familiar with Family Code Section 262.352 in the version that passed previously in 2021. Today, I want to tell you a very true story about some people I know too well. And their experience with this bill and what this would have as an effect on them and their family. Candace and Stephen, in 2019, their adopted son, William, was adjudicated of 2 counts of aggravated sexual assault of a child for the sexual abuse that he perpetrated in his home with his parents against his sisters. William was sentenced to 2 years of probation with his county's juvenile probation department, but by November of 2021, William was on his 3rd residential treatment center, and Candace and Stephen had paid $5,000 in child support. They had paid $5,000 in attorney's fees for William, and they were continuing to pay for weekly private therapy for their daughters. Despite William's continued need for treatment, probation was ready to close his case, and without an alternative placement, he would be returning home to Candace, Stephen, and his 2 victims. At the time, William was receiving treatment at Pegasus Schools, and as many of you may know, it is the treatment center in Texas for youth who have problematic sexual behavior problems. However, Pegasus Schools takes only just 2 types of children: those who are working with the juvenile probation department and those who are in DFPS's care. Therefore, Candace knew that she would not be able to continue to obtain the treatment that William so desperately needed. And so she made the difficult decision to self-report online as a refusal to accept parental responsibility for her own son. I'm happy to tell you that today Candace and Stephen do share joint managing conservatorship of William with the Department of Family and Protective Services. However, had House Bill 4905 been the law at the time, the way it is written currently, Candace and Stephen would have had a dramatically different result. House Bill 4905 would have required that they pay child support and medical support to the department in an amount equal to the cost of William's care. And as a specialized level of care child at a residential treatment center, that would have been $6,000 per month in residential costs alone. Candace and Stephen would have also been required to pay Medicaid costs despite the fact that they provided Blue Cross Blue Shield private insurance for their son. And they had continued and will continue to support William in various other ways, including their visitation trips to see him 5.5 hours away, clothing, school supplies, gifts, and most of his necessities. While that family continues to pay several $100s per month in counseling for William's victims. By including shall in the legislation as written, this bill requires that the court order an untenable amount of child support, and JMC would not have been an option. You ask yourself why that is important, and it is because this proposed legislation also removes an exemption from the definition of neglect for parents who parent these children by saying that unless their case ends in a joint managing conservatorship court order, they could be found reason to believe for neglect. Stephen was a 22-year police officer veteran who worked as a school resource officer at a local elementary school. Had a reason to believe finding been made against him, he would have lost his job, and his family's livelihood would have been at stake because of the terrible choice an 11-year-old child adopted from foster care made. Is this the intended consequence of the proposed amendments? I certainly hope that it is not. But if even just one family suffers this consequence, it's far too many. The relinquishment avoidance program, the RTC bed projects, those things that exist currently are exactly designed for these types of cases. But when we require that these investigations end in joint managing conservatorship court orders, while simultaneously making it impossible for families to achieve them, we've eviscerated those programs entirely. There's more issues with the legislation with respect to DFPS having to find placement prior to a court order.
You can wrap up, please.
When they can't do so until after a court order has been obtained by their current policies. And the department's ability to say that they're simply not able to provide these services leaves people like Candace, Stephen, William, and his sisters without help. So we ask that you do not pass the amendment as written.
Or the bill. Thank you for that testimony. Have you gotten comment? I don't know exactly when the committee sub came. Have you gotten comment? I mean, is there nothing redeemable in the bill? In your opinion, is it just completely the wrong direction? Or are there some, I mean, we're trying to address an issue I think you're aware of, and I really do appreciate your testimony. I don't agree with the if just one logic, because frankly, we're not dealing with just one. We're dealing with, we're dealing with thousands of kids around the state. We've got to make the best decision for everyone, and I don't care what you do, you're going to have problems on one side or the other of anything we do here. And so the one matters, obviously, but the policy matters as well. So are there some changes, or are you just saying it's absolutely the wrong direction, we shouldn't do anything in this?
No, I appreciate the question. I think there are absolutely some changes. And with respect to the concern about how do we make this work for a broader number of families in lieu of just stopping the process because one family might suffer, I think having language that leaves some of the requirements to the discretion of the court. The proposed legislation includes language like shall, especially with respect to things like child support and medical support costs. Some of these children are placed on child-specific contracts that cost upwards of $20,000 a month.
It says shall, but there is also wording about indigence. We could probably get that, I think you could clean that up where it's, a percentage or I think.
I think if it was a percentage that was more in line with the Texas Attorney General's, regular percentages for child support and not something that went egregiously above and beyond that, it would certainly be more salvageable or fix that issue with respect to that particular family. Many things in the bill are positive, making sure that these parents actively participate in their children's treatment, making sure that we're finding safe and appropriate placements. These are exactly the children we don't want sleeping in hotels.
Right. So would you be able to get written comments to the bill author, and we don't have much time, so
Absolutely.
Really quickly? And then
Certainly, I would love to.
I'm certain that those will be taken into consideration.
Absolutely.
That's all right. I think we've got some nods. I think we know this is an important issue, and I think, honestly, if you're willing, I would love a couple of y'all to be willing to jump in on this and get it written in a way that's agreeable. So thank you very much for your testimony. Members, any other questions?
Thank you very much.
All right, thank you very much. Chair calls Julia Hatcher. And I'll show you as Julia Hatcher testifying for self and Texas Association of Family Defense Attorneys against the bill. Is that correct?
That's correct. Chairman Frank,
Yep.
committee members, my name is Julia Hatcher. I'm an attorney in Galveston. I'm also the president of the Texas Association of Family Defense Attorneys, and we are against this bill. TAFTA has attorneys all over the state who represent parents in these dire situations. We found that the caseworkers have either never heard of the JMC program, they think it only applies to post-adopt kids who are coming back into care, or they just don't want to deal with it. But the legislature put the JMC program into effect for a reason. It was to help parents and children, not hurt them. A group of our members recently approached DFPS, and we actually had 2 meetings with leadership, including the commissioner, where we shared personal stories of what is happening around the state with these kids. It's not just one. It's not just one kid. It's not just one family. It's happening all over the state. For instance, I represent a mom who refused to pick her child up from a psychiatric hospital after the child had assaulted her and her siblings because the mom knew what was best for her child, and that was for her to be somewhere where she could get the help that she needs. She requested the doctor at the psychiatric hospital to send a referral for the child to an RTC, which he did. This was the 12th time that the child had been in a psychiatric facility in the last 6 years. She had recently completed juvenile probation for assaulting her mother and her brother, and my client had asked juvenile probation at that time to help her. They called DFPS, and there was a huge meeting at that point. The mother said that the younger children had made outcries of sexually inappropriate touching, but because there was nothing specific that was said, DFPS did not investigate it, and they sent the child back home. These kids were facing revolving door situations. It was not a month later before this child ended back into a psychiatric hospital. These children get stabilized with medicine at a hospital, and they say, okay, they're ready for discharge. They get out. Within a month, they're back in. We need to start helping these kids. This is a cycle that needs to be stopped. You're all wondering probably what happened to my client's child. Well, DFPS didn't believe us when we said that it was a child who needed help. They wanted to blame my client. That's the easy thing. Blame the parents. The parents aren't raising their kids correctly. Okay, well, this child had been in counseling through the LMHA since 2016. She wasn't getting the correct counseling, obviously, because nothing was helping. She was attempting suicide. She was running away. She was cutting herself. So we went to court with about 2,000 pages of mental health records. Unfortunately, the judge sided with DFPS, did a removal action so the state could have custody, and the state placed my client's child with her aunt over my client's objection, and guess what? The child ran away within a month, cut herself, and ended up back in a psychiatric hospital. She was psychologically evaluated and then placed in a temporary emergency shelter where she remains today because nobody in the family will take her into their home because they're all afraid of her. These are real problems with children, and these children need help. But the fix is not to make the JMC program so onerous that nobody can get into it. The most concerning issues that we have are with subsections 2 and 3, because DFPS can just say, oh, we don't have the services, we're not going to take responsibility. Anyway, that's about all I have to say. If you have any questions, I'd be happy to answer them.
Yeah, thank you. I guess it would, almost the same question. If you could get the specific comments, if you feel like some of the direction is good, but you have concerns, if you can get those in writing really quickly to the bill author, that would be really appreciated.
Okay.
And I do think there's I do think there's a bigger issue. I think to some degree we're also asking DFPS, who's used to looking at abused children, to also take care of this same type of child, which is to me almost in a different category. But I'm not sure that's not going to be something we address in this bill. So, members, any questions of Ms. Hatcher? Thank you very much for your testimony, and really would appreciate your feedback to the bill author. All right, Chair calls Stephanie Muth. I show nobody else wishing to testify. I've got you. Thank you, Commissioner. I've got you as Stephanie Muth, DFPS resource only on the bill.
Good morning.
Is that correct?
That's correct. Stephanie Muth, Commissioner at the Department of Family and Protective Services, and I'm here as a resource. I'm happy to answer any questions, and also I'll just provide a little bit of context. Chair Frank, I think, had approached the agency even prior to me starting. We have an issue, and I think the witnesses before did a very good job of explaining systemic issues that we're facing in Texas, and I think this is a policy issue for consideration by the legislature on what the role of the Department of Family and Protective Services is in these instances. So as you all know, we are struggling with children without placement currently. We have about 70 to 80 kids on any given day that are housed in unlicensed settings. That's a very difficult situation for those children. They're not getting appropriate services. Some of them are coming out of psychiatric hospitals. They're decompensating in those hotel rooms. It's not a good situation for the child. And then also our staff are put in, have overtime. It's an incredible strain on them. They're put in unsafe situations. So, I think it's important for the legislature to have the policy discussion around what the problems are and what the appropriate solutions are. So, we had provided some suggestions, understanding that this would be a conversation, but at the request of the chair and with Representative Campos as well. So happy to answer any questions.
Members, any questions? So I appreciate it. I will just say, I know you've been on board 3.5 months?
Something like that.
No, and honestly, I have already found just a lot of different solutions. I don't agree with all the solutions, but you're coming up with solutions to systemic problems, because there really are. There's a lot of things to address. This one, I don't think we have a full handle on, but I would. I know Representative Campos, and I'm hoping Representative Ramos is nodding her head. I'm hoping can work towards getting something on this. I think we need to look at how kids are coming in this particular way, because to me it is a lot different than abuse situations, and the solutions are different, and yet I think we're trying to shoehorn them into that same system. Do you? And I'm going to get to a question. So do you? Do they go through the same system in a relinquishment? They can't really, because there's no abuse alleged in a refusal to accept parental responsibility. What is the process? Does it go to a caseworker immediately? What is that process?
If you don't mind, Chairman, with my 3.5 months, I'm not sure I can fully describe that
No, that's-
process, but we do have another resource from the department here, Marta Talbert,
No,
who
that-
can answer that.
That would be great, and I appreciate that. So Chair is going to call Marta Talbert, and thank you, Commissioner.
I'll stick around.
Stay close. Thank you. I've got you as Marta Talbert, DFPS resource on the bill. Is that correct?
That's correct.
All right, thank you. So the process when you get a refusal to accept parental responsibility, the wrappers that we talk about, how does that process, or is it the same process, or it's got to be a different process, I guess, than the normal one, or tell me?
No, it's the same process. It's assigned to an investigator. At that time, they complete an investigation, gather information, and if it ends up being a wrapper, either TMC or JMC, it goes through the same process of us filing an affidavit, going to court. It'll be the exact same process.
Because you're almost never going to, yes, please, thank you. Representative Ramos, thank you.
Thank you, Chair. Going along the line of what the question that he just asked. So in my personal, I have a little neighbor, and I think about the cases that you were referencing. I have a little neighborhood child who comes to my house and has some mental issues, and beautiful child. She's enormous. She's taller than I am, and the parents are doing everything they possibly can, but when she doesn't take her medication, she'll come to my house and cry and, call the police, and there's no abuse. There's clearly no abuse, but she didn't take her medication, and once she does, I kind of dig through, but as teenage kids, they'll tell you a little bit and they'll stop. So there is no abuse in terms of, something to call CPS and whatever. And the parents are doing everything they can. She's refusing to take her medication. This child is 6 feet tall. She's a big little girl. And so in this situation, it's not calling CPS for abuse or neglect because this child is just a big little girl who's a teenager but when she doesn't take her medication, she kind of goes off the rails. And so right now she's in a space where they're providing support for her mental health issues, but it's concerning to me that the parents have been doing everything they possibly can to care for this child and trying to find the right spaces for her to put her in a home, and it's very expensive, and these are working middle-class families. And so in this situation, getting CPS involved, it's not child abuse or neglect. So at what point, or in this situation, you said it's exactly the same. In this situation, the way the bill is written, the department would have JMC over this child, even though these parents have done everything they possibly can to help this child. How does that fit into this space in terms of bringing the department or involving the department in this personal family situation where their parents are absolutely doing everything? It seems like it's almost punitive, the way it's written, or could you speak a little bit to that?
Yes, I think I'll start kind of from the beginning, because when people call statewide intake, they're calling because of concerns for abuse or neglect. So it starts there with those worries of abuse or neglect. We shouldn't get phone calls or referrals into our system if it's not concerns for abuse or neglect. So I think it starts there, and anything we do goes to an investigation, right? So it's going to come over to investigation for us to determine if there is abuse or neglect. So there's a suspected abuse or neglect, call it in, and then we work the investigation. I will say the difference sometimes is though if we disposition or not, right? So
If you what? I'm sorry?
If we disposition a
Disposition,
case.
thank you. I just
Right,
couldn't understand
so
the word.
in that certain circumstance, if we end up being involved with that family and we are trying to help and do resources, maybe there's not an actual RTB, but the process will be the same coming through our system.
Anything else?
If
And-
you don't
and-
mind,
Actually, so Commissioner Muth, go ahead. I just want to
Yes.
Or actually, just identify yourself. Since y'all are both resource
Yes.
witness, just before you talk, and just identify who's talking.
Stephanie Muth, Commissioner at the Department of Family and Protective Services. And I just want to add, I mean, I think that's the complexity of this issue, because the problem for the department is that we also don't have the ability, if there is not an appropriate placement for the child, and that's the issue that we're struggling with right now. Our caseworkers in a hotel room are not any better able to provide those appropriate services than a parent. And so it's not a situation with an easy answer on one way or another, but that's the struggle that we're having as well, in that we're exhausting efforts to attempt to find appropriate placements. And there is work that's being done to increase capacity within the system, but where we are today is that every night there's 70 to 80 children that we do not have a placement for, that are staying in unsafe situations, and some of them are there for a period of time. I mean, and it's not we have security. It's not that it's an unsafe situation, but often, like I said, they're coming out of a psychiatric hospital, like in some of those situations that were described. They're decompensating in a hotel room. It is not an appropriate placement for the child. So I in no way want to minimize the complexity of the issue. It's just that there's not an easy answer for on our side or for the parents.
Yeah, Representative Ramos.
And I appreciate your honesty, and that, for me, is the concern of why I haven't called CPS. In another universe, somebody may say it's neglect, but I know the parents are doing the absolute best they can, and when she doesn't take her meds, she comes to my house at 10 o'clock at night crying. I contact the parents, and they come pick her up. And so I can see, I would be terrified if this baby girl got involved in became one of those cases, because I appreciate the honesty and that the department can't do what her parents are doing everything they possibly can do. And so it is a terrifying situation for these children, but something that we absolutely need to address. And so I appreciate Representative Campos for trying to do something to fix this situation, because we love our children and want to make sure that they're in the best space. But sometimes if the parents are doing the best that they absolutely can, I would just hate to put them in a situation that it's a bind for them as well. So thank you.
Thank you very much, Representative Campos.
Yeah, so I just wanted to talk about one situation, because I do appreciate what the witnesses are saying, and I completely understand, but there's just all types of cases, and so we're all just taking baby steps and trying to collaborate and do the best that we can. But there was one case where CPS was called, and on a little girl, the mom, and then the mom just said, I don't want to deal with her, send her to dad, but CPS was already involved. One thing led to another, and she had a lot of mental illness and winded up running in the middle of the street. The caseworker chased her down. Both of them almost got hit by a car. So I've seen so then we got to take care of the investigators or caseworkers. We got to take care of the kids. We got to help the parents. So it's a huge issue that we just got to dive into and just do the best we can, because it's really tough when you talk to the investigators and they tell you the stories that they've been through with these children that have mental illness. I mean, there's been a caseworker that was beat. There was another one that was sexually assaulted. I mean, there's just all type of cases, and so we're all just trying to do the best we can. And so thank y'all for working with me on that.
Thank you.
Thank you. Just one more question. So 70 kids or so, and I haven't seen the numbers in a couple months, but it seemed like they were less than 20 days on average. It was a fairly short, too long, but fairly short amount of time. Is that about right? But anyway, well, but it's but regardless of the length of time, it is pretty temporary. Where are they going from there?
So we've been,
Commissioner Muth.
Stephanie Muth, Commissioner at Department of Family and Protective Services. So we have been really looking at the situation from both individual children and trying to find the appropriate placement for those children, but also from a systems perspective, what are the trends? What do we see? And there are some children that are without placement for a short period of time. And typically then, I mean, we are trying to find a kinship placement, whatever, if there is a therapeutic foster home, a residential facility, we will look at all options for those placements. We also have some children who end up staying for much longer periods of time, and unfortunately, in some situations, they end up aging out of foster care while they're so there's a number of children that are 17 or older who are in that situation, and they may be there for months, and then they end up aging out of foster care in that setting.
All right, thank you, members. Any other questions? I warned you at the start, this is not the, I mean, most of the bills we have are hard. This one is one of the hardest, so thank you. Thank you very much, Commissioner and Marcia. Thank you very much. Chair calls Maureen Ball. Chair calls will show you as Maureen Ball, self against the bill. Is that correct?
Yes, that's correct.
Okay, thank you. And I show nobody else wishing to testify on the bill, so if you are, please get registered. Go ahead.
Yes, Maureen Ball, self. I'm an attorney that I represent parents and children in CPS cases. So I've actually represented a child that went through a situation like this that had a mental health problem that her adoptive parents were having a struggle dealing with, and she ended up in one of those hotel rooms. And there was a struggle finding her facilities. But the goal was to get her mental health services. And that's why government exists. That's really why CPS exists, to help these children and these parents who are struggling in a situation. So the remedy is not to vote for this and put more burden on the parents to pay for something that they can't. Now, if they could, they would, but they can't. So they're calling CPS to say, you guys are the experts. You're supposed to be the experts. You're supposed to know where to place these children with mental health problems. You know facilities. You've got contacts in these facilities. You can break through the bottlenecks that I'm having as a parent. So I strongly urge you to not pass this bill. There are things that need to be done for the children, for the foster care children and the parents, but this bill doesn't do it. So I'm speaking against this bill.
Okay, thank you very much. I'm going to ask the same question, and I'm not trying to force a bill, but I think the prior two folks that were attorneys were also saying there are parts of this that actually are positive and parts that are very negative, and you're testifying against. Is it the whole concept of the bill is bad, or are there specific parts of the bill that if they changed, could we get there?
I don't have the bill in front of me. The one that really stuck out to me was requiring the CPS to have a facility before they will accept the case. And that just doesn't really happen. I mean, they have to go through the process. There's forms that you fill out and all that. And so the parents are in distress. They need help immediately, whatever that help looks like. And that's what we're all struggling with, is to improve the help that they can get immediately. The second thing is requiring these parents, adoptive parents primarily, I think, but nevertheless, requiring them to pay for these services. I mean, it's not fair to our community that we dismiss a child from services because the parents can't pay for it, and then the child ends up having severe problems that we see all over the news. And everyone's like, how come someone didn't do anything about this before they had a very serious problem? This is parents looking for help to eliminate the child from getting into serious trouble and harming themselves or others.
Okay, thank you. Members, any other questions? Thank you very much for your testimony. At this time, there are no other witnesses signed up to testify. Is there anyone else wish to testify on, for, or against House Bill 4905? Seeing none, public testimony is closed, and the chair recognizes Representative Campos to close on House Bill 4905.
HB 49 will lower the number of children without placement, which is a huge issue that we hopefully can eliminate and get the children the help that they need. And with that, I respectfully ask for your support. Thank you, and I close.
All right, very good. The committee substitute is withdrawn, and if there's no objection, the bill will be left pending. The chair hears none, and House Bill 4905 is left pending without objection.